The chair recognizes the gentleman from Virginia.
Madam Chair, I yield myself such time as it may consume.
Without objection.
Madam Chair, my amendment prevents the Department of Justice from requiring mandatory donations as part of settlement agreements. The Department of Justice is systematically subverting Congress's budget authority by using settlements to funnel money to third-party groups. An investigation by the House Judiciary and Financial Services Committees reveals that in just the last 10 months, the Department of Justice has used mandatory donations to direct as much as $500 million to activist groups. These payments occur entirely outside of the congressional appropriations and oversight process. In some cases, the Department of Justice is using mandatory donations to restore funding that Congress specifically cut. This is money that could otherwise be going directly to victims. The Department of Justice continues to resist document requests, but what little has been provided confirms that activist groups which stood to gain from mandatory donation provisions were involved in placing those provisions in the settlements. The committees raised concerns with the Department of Justice in 2014, but instead of suspending the practice, the Department of Justice has doubled down. It recently entered into an over $50 million settlement relating to robo-signing. $7.5 million of that did not make it to victims. Instead, it went to a third party. Incredibly, the settlement specifically provided that there would be no oversight of the money. The situation is even more egregious when one considers that the required donation will nearly double the net assets of the DOJ specified recipient. It is deeply troubling for that to happen at the unilateral discretion of the executive branch. This amendment takes no money away from any organization. It is purely prospective. It ensures that settlement money goes either directly to victims or to the Treasury for elected representatives to decide how it is to be spent. It is critical that we act. The Department of Justice is ignoring Congress's concerns, increasing the use of third-party payments, even as we object. The purpose of enforcement actions is punishment and redress to actual victims. Carrying that concept to communities at large or activist community groups, however worthy, is a matter for the legislative branch and is not to be conducted at the unilateral discretion of the executive. This is fundamentally a bipartisan institutional issue. There was abuse of third-party payments in the Bush administration. This amendment is about preserving Congress's appropriations authority, and I urge my colleagues to support this amendment and reserve the balance of my time.